Good afternoon, everyone. As Adam said, we're going to talk to you about disclosure, in particular specific disclosure. Well, I think it's in that context, but worth noting that for all the work that we pour into preparing witness statements and preparing cross-examination, the courts have said this about the approach to evidence that they should take. For example, this quote in the case of Guestin: "The best approach for a judge to adopt in a commercial case is to place little, if any, reliance at all on witnesses' recollections of what was said, and to base factual findings on inferences drawn from the documentary evidence. And the value of cross-examination is merely in subjecting that record to critical scrutiny and also to understand the witnesses' motivations and practices." And it's with that in mind, that importance of disclosure, which you hardly need to be told about, we're going to give you some tips on getting the most out of the disclosure process. So I'm going to give you a brief overview of the two regimes before going into looking at specific disclosure applications, how to use the other side's disclosure to build a case and how to make the applications and what to look for. I'm going to say then a little bit about imaging orders and their relevance to the disclosure process. And then Sophia is going to talk about redactions and confidentiality and non-party disclosure. So really, by way of brief overview, I'm going to say something about the two different regimes that we'll come across in business protection type cases. Firstly, the catchy name CPR Rule 31 regime, which is used in the King's Bench Division outside the commercial courts and the technology and construction courts. And that is the old usual disclosure regime supported by Practice Direction 31A and Practice Direction 31B. And the only point we really want to make about this is that even in the old regime that applies in the King's Bench Division, there are different types of orders that the court can make. There's a suite of orders set out in CPR Rule 31.57, which include, for example, issue-based disclosure, or merely disclosing the documents that you rely on. But I think it's most likely, in the cases that we're doing, that the order that will be made will be a specific disclosure order at the outset. And that's partly because that is commonly still made, but also, of course, because in a lot of the cases that we're talking about, there will have been an interim hearing at which an interim junction will have been made or not made. And it's at that point that the court first considers and makes orders in relation to disclosure. So there is often no case management conference and not even necessarily a pre-trial review. The court simply makes disclosure orders at that stage. So much for the King's Bench regime. In the business and property courts, there's a different regime, the Practice Direction 57 AD regime. It is entirely separate. It is, has its own set of rules and guidance in there. For present purposes, I just want to make 2 points, which really leads into what we're saying about the importance of specific disclosure. The first point is that, unlike in the King's Bench Division, you need to give initial disclosure with your pleadings. And the only thing I want to say about that is it's not that onerous. There's no duty of search at that point. It's simply a question of disclosing documents that you rely on or the other party need to understand the case. And in the main disclosure stage, the court requires the parties to identify a list of issues for disclosure. And against each of those issues, each of those issues, it asks the court to set out what model of disclosure they want to use. There are two types of models, one's without searches and one with. And the one that will commonly apply in cases of this kind will be the Model D approach in relation to almost all the issues, apart from not very controversial ones. That's the narrow search-based disclosure, which is the most similar to standard disclosure. It's just documents which are likely to support or or hinder the party's case or another party's case. So I mention all of that partly to identify the limits of standard disclosure or Model D disclosure. And I put up on that slide this quote from the case of Digicel, which is often quoted in specific disclosure applications, in which the court said, in litigation, it may only take one revealing statement in a document, perhaps in an email, to show clearly what people really thought or what people really were intending to achieve, a matter that might not have been revealed in tens of thousands of other documents in the trial bundle. And then going on to talk about what the duty of reasonable search, the court said this in the last 3 lines. The rules do not require that no stone should be left unturned. This may mean that a relevant document, even a smoking gun, is not found. And that is a position in relation to standard disclosure. It's not that every mailbox has to be searched or that it has to be searched for a particularly lengthy period. It is what is reasonable, which is why parties need to make applications for orders for standard disclosure. And, but before talking about the specific disclosure stage itself, I want to say something about the pleaded case. And this actually picks up on a couple of points that Adam and Lottie made in their talk. It's a pleaded case that frames the scope of any disclosure application. The disclosure has to be relevant to an issue between the parties. And it's therefore the case that the parties should at that stage be thinking about what issues they should and shouldn't be raising in anticipation of disclosure having been being required on those issues. So, for example, as I say, the claimant may be entitled to more disclosure by pleading breaches during employment. And indeed, that was the case, I think, in the case of Dare that Adam referred to. It was originally the speedy trial was just only going to be about the post-termination covenants. And it was only latterly that the claimants tried to bring breaches during employment, which brought in, therefore, the question of the issue of reasons for my clients and Adam's clients' absence, which was relevant ultimately in the outcome of the case. So that's quite common. Claimants plead breaches during employment in order to get disclosure, which might be embarrassing to a defendant. Conversely, a defendant might want to not plead a particular issue in case it gives rise to a disclosure obligation. The point I make on the last slide there, Dysel and Pellery, the case that Adam mentioned, is this, that even when a covenant is found to be enforceable, the court doesn't necessarily enforce the covenant. It's a question of its discretion. And we see that most commonly at the interim stage. If there's, for example, been delay on the part of the claimant in coming to court, if the court takes the view that there's been too much delay, then the court might not grant the injunction, even though they thought the covenant was enforceable. Another consideration, which is relevant there, is equity does nothing in vain. The defendant might say, well, even if the covenant's enforceable, it's pointless to grant it because of what I am going to do. And that was an issue that arose in the other case that Adam mentioned, where ex-employee pleaded that even if the covenant was enforceable, it shouldn't be enforced as a matter of discretion because the work that was going to be done with the new employer was merely preparatory. That is, I think Adam alluded to this as well, that's quite a difficult argument because what the courts say is at the final stage, not at the interim stage, is express or implied negative covenants will in general be enforced by injunction without proof of damage by the claimant. So even if a defendant were to say, well, look, there's no harm in me doing this work, it's preparatory, we're not going to be up and running for several months, that is a difficult argument to make. But beyond that, what it might create is a disclosure obligation, in particular on the part of the new employer. They might have to disclose a lot of information, some of which is confidential, about what they're going to be doing in the new role in order to make that point good. And if it's a difficult point, even if it's on the face of it a sound one, that's something that should be considered at the earliest stage as to whether to plead that or not. So turning to specific disclosure applications, particularly given the speed at which we hurtle towards speedy trials after interim hearings, it's, I think, often worth, as parties often do, writing to the other side in advance of standard disclosure or Model D disclosure and saying, we expect to see this in your disclosure. That's all well and good. But the case of Bates and Post Office that you'll be familiar with has some salutary warnings about the need to go beyond that. In that case, the court recognised that the disclosure of the defendant, that's the Post Office, was deficient. Not only had they not disclosed documents they should have, they'd said they'd made untrue statements about disclosure before the court. And the claimants complained about this, and the court said, yeah, you're right, they have done all these things. They should have given disclosure or should have given disclosure earlier. But the court said this: the Post Office is, however, correct to point out that there have been no specific disclosure applications mounted by the claimants. General complaints about disclosure only take a party so far, and that is not very far if deficiencies are known about in advance of trial and no applications are made. And that's particularly difficult, again, in the context of speedy trial, because often parties don't really set out a timetable, a space in the timetable for making specific disclosure applications. There's often no case management conference, or often no pre-trial review. So I think it's worth building into the timetable an opportunity to make applications of that kind, so it isn't left to the beginning of trial. So I'm going to make a couple of points about what to look for in the other side's disclosure. And I say that with this caveat: obviously each case turns on its own facts, and each disclosure application will be determined according to what the pleaded issues are in that case. But Tullett-Prebon is an interesting case, and it maybe raises issues about disclosure that assist a claimant and don't assist a defendant in ways that they may not necessarily have anticipated. Now, the particular facts of that case are relevant only to this extent, that there were agreements, written agreements, that the ex-employees had agreed with the new employers that were called forward contracts, agreements to start on a certain date. And the court thought, well, that might be in breach of obligations owed to the ex-employer, if they were, for example, during a covenant period. But what the court did is order disclosure of certain documents that they thought would be indicative of the ex-employee's intention. One of them was the provision of an indemnity should the current employer take action against the ex-employee. So they're not, it's neither common nor uncommon, but often ex-employee will have an indemnity from the new employer for costs and damages. And the court said this: indemnities carry two dangers. A recruit who has an indemnity is more likely to break or run the risk of breaking his existing contract. And also, though it doesn't enable the new employer to tell the employee what to do, it comes close to it. So I think ex-employee needs to be aware that that might need to be disclosed. And the same actually goes for, on the facts of that case, the new contractual documentation. In that case, there was relevance of provision of substantial salary and commission payments to get together with substantial signing on payments. So if those have been agreed by the ex-employee with the new employer, it may be that those need to be disclosed as well. Obviously, defendants as well as claimants need to be aware of that. So I'll make some other general points in that slide about some other steps that might be taken to identify gaps in the other side's disclosure. But I'm just going to hand over to Sophia now to deal with what a defendant might look for.
As defendants' counsel, you're often looking for evidence that goes to the reasonableness of the defendant's post-termination restrictions. For example, in the Dare case, we were looking for evidence regarding the shelf life of confidential information, about whether a replacement had been hired for our client yet, about his interactions with brokers and with fellow colleagues in the claimant's business. When you're looking at the disclosure that you've been provided, you will often see, large tranches of emails, but you might be looking at those thinking, well, where are the WhatsApp messages? Where are the call logs? Where are the Teams messages? Where are the Slack messages? It's often when you look at the whole body of material you've been provided for in standard disclosure that the gaps appear, given the myriad methods of communications that we now use in day-to-day professional life. And that might be how you start formulating a strategy to attack the other side's disclosure. We wanted to direct you in this slide to an often overlooked provision within the CPR rules and also within Practice Direction 57 AD. It's a useful one that can really assist a party because it allows you to obtain inspection of a document that is mentioned in a statement of case or a witness statement. And mentioned can mean directly alluded to. And you can see in the third bullet point, a case called a Batcher is mentioned where this particular rule was interpreted by the courts. And the quote, "It's not a difficult test," is used in that judgment. It's a powerful tool because there isn't a freestanding requirement to show in order to get inspection under this provision that the document is necessary. The relevance or the confidentiality of the document comes in at a later point when the court is looking at its discretion to grant an order under this provision for inspection of the document. It's not an automatic right, but it's the norm that the discretion is going to be granted in favour of the applicant, and you will get inspection of the document as a result. Now, if you overreach yourself in a specific disclosure application, you'll often be met with the accusation that you're on a fishing expedition, trying to get more than you're really entitled to. It's hard often to know what side of the line a proposed application falls on. Is it a fishing expedition or is it likely to be a successful specific disclosure application? And of course, the touchstone for the court when it is considering your specific disclosure application is going to be the pleaded case. As Niran said, that's the frame for disclosure. It frames disclosure. The court, of course, has to be satisfied that, at least on a prima facie basis, the documents that you're seeking in specific disclosure are or have been in the other side's control. That said, the application can be based on the probability that they do, arising from the surrounding circumstances or in part on specific facts deposed to. In this slide, we want to set out how we think you can ensure that your specific disclosure application is successful. Firstly, you want to seize on what you've got in standard disclosure to show the court what the gaps are, that there are gaps and that you need the documents which haven't been provided to you. Can you demonstrate those gaps not only through standard disclosure, but also through publicly available materials? For example, in the DARE case that Adam and Lottie talked you through, there were LinkedIn posts that suggested that a new recruit had taken the job of our client, the second defendant. We used that as the basis for seeking specific disclosure about that individual's role from the claimants. Can you address those gaps in correspondence and seize upon vague assertions or equivocations that you get back in response to make the application? And finally, if you can make a targeted application in good time rather than on the first day of trial, despite the expedited timetable that hurtles you towards the speedy trial, that is more likely to be successful. I'm now going to hand back to Niran to talk about interim imaging orders.
So again, one of the features of this litigation is you often have start the process with an interim order, and if there's been misuse of confidential information, the successful claimant applicant might have got an order that the defendant's accounts and devices be imaged. Just worth noting that there are two relevant processes here. First is the imaging, which is merely an evidence preservation step. And the second, completely different step is disclosure, specifically inspection of the contents of those images. There is a standard imaging order, only deals with the first part. The imaging bit doesn't say anything about disclosure, or inspection, looking at those documents. Now, I think claimants at that stage, having got the interim imaging order, just think, as of right, that they, agreeing orders with the other side, can have a look at the contents of those images, and that they can do so at that time. And sometimes that's what a defendant will want. So, look, I've done nothing, let's have a look at the images. But it's worth recalling what the Court of Appeal said in the case of TBD. They said the presumption is still that disclosure takes place in the normal way. You've got the image, you hold it, you plead out the case, you make orders, and then you have orders for, let's say, standard disclosure, and you might use the image at that stage. Now, I don't think that's often how claimants or indeed parties behave when they have imaging orders. Now, that presumption can be departed from if there's sufficient justification. Court of Appeal doesn't tell us what sufficient justification means, but it did refer to the case of A and B. And one of the factors that determines whether or not the claimant, probably through the expert, can search the images at that point, is the extent to which the defendant, the ex-employee, can be trusted to carry out their own disclosure. And trusted can be an issue of integrity, but it also can they be trusted to get it right as to what's disclosable or not. And the claimant might say, look, it's urgent, and the claimant may say, well, I have sufficient resources. But there are certainly grounds for an ex-employee to resist the inspection of the image at that stage, if they say, for example, there's no urgency and I can be trusted to carry out the inspection exercise in due course in the proceedings. Another point at which imaging becomes relevant is in the context of disclosure itself. So imaging at the interim stage is about evidence preservation, as I said. This is different. What the courts have said is that under its inherent jurisdiction powers, ultimately as a matter of case management, what the court can do, if, for example, a party isn't playing by the rules in terms of their disclosure and is being shown to do that, is actually making an order that their devices be imaged and be inspected under some process, for example, with an expert. And that can be quite a powerful tool and certainly quite a powerful stick to threaten the other side with if they're not carrying out disclosure. Because images although it's not that intrusive in some ways, it's just imaging, but of course people can have very personal documents on there, not to mention photographs, etc., not to mention privileged documents. So the threat of the other side of actually imaging their devices can be quite a strong one in requiring the other side to carrying out their disclosure obligations properly. And the court recognises that. It will not do that lightly. If it does do that, it will put in place protections, such as in that JD Classics case, having a junior barrister acting as a sort of supervising lawyer to make sure the process was done fairly, and indeed actually asking the other side to pay the costs of it. Handing back to Sophia now to do with confidentiality and then third-party disclosure.
Our penultimate topic is confidentiality and redactions. The Business and Properties Court regime has a specific provision, paragraph 16 of Practice Direction 57 AD, that allows for redactions of any data that is irrelevant to an issue in the proceedings and is confidential or privileged. The same approach is taken under the CPR rules, the Rule 31 regime. But you must have good grounds to make the redaction. And there's been some disquiet, and that's expressed within the WH Holding judgment, which quotes from the practitioner's manual documentary evidence about redactions being abused and there being too liberal an interpretation placed on irrelevance, so that is being used, the redactions are being made too widely to relevant documents. So you can't simply hide, for example, relevant negotiations with a new employer over the terms of your package simply on the basis of commercial sensitivity, and that's an important point to highlight to clients. We next wanted to cover the issue of non-party disclosure, which may be a really, really important tool for claimants to use in business protection cases, and something that those acting for defendants should certainly be concerned about. The provision that entitles you to get non-party disclosure is contained in CPR 31.17, and it's reproduced within Practice Direction 57 AD as well. The conditions you have to meet to get an order against a non-party for disclosure are that it's likely to support your case or adversely affect the other parties, and that it's necessary to dispose fairly of the claim or to save costs. And ordinarily, the cost of compliance with the non-party disclosure order is paid by the applicant. This came up in a related DARE case, a non-party disclosure application. Adam was talking largely with Lottie about the case Niran and I were involved in. In another piece of DARE litigation against Mr. Urson, there was a non-party disclosure application made against Onyx and against 3 senior employees of Onyx. And what was being sought in that non-party disclosure application was primarily communications relating to the recruitment and offer negotiations that Onyx had had with Mr. Urson. And the reason why they were seeking those documents from Onyx and these senior employees of Onyx was that Mr. Urson had admitted to deleting relevant documents. And it was that allowed them to bring this application in effect. What was an issue in that application was whether the documents that were being sought by the claimant were really in existence. But Mr. Justice Lavender favoured one decision, Pride Valley, over Howglen, and said actually the existence of the documents wasn't a separate limb of the test. All that had to be shown by DARE was, as set out on the previous slide, whether the documents they were seeking were likely to support their case or adversely affect Mr. Urson's, and whether they were necessary to dispose fairly of the claim or save costs, and he was of the view that those 2 conditions were met. The objections from Onyx were that they would be required by the order to disclose commercially sensitive information to their great rival, DARE. That didn't wash with the court. They said, well, privilege and confidentiality are provided for by CPR Rule 31.17. So the order was granted against Onyx and the senior employees at Onyx, and the costs of the application were reserved. As I've said, the norm is that the applicant pays the costs of a non-party disclosure order, but in this case, Mr. Justice Lavender said there were exceptional circumstances that warranted reserving the costs, and those included the history of deletions by Mr. Ursan, and the fact that Onyx might, on the claimant's case, have provided an indemnity to Mr. Urson, either formally or informally. They were standing behind him. And so those factors took it outside of the normal process, and costs should be reserved pending what happened in the trial between DARE and Mr. Urson. That trial never happened, as there was a settlement, so we don't know what would have occurred. But that takes us to the end of our talk. Thank you very much.
Thanks very much, Niran. Thanks, Sophia. And indeed, thanks very much to all of our speakers for the day. That brings us to the end of what's been a long series of talk, which I hope has given you all food for thought. There's a lot going on, isn't there, in the employment law world at the minute? We haven't covered all of it, but hopefully we have stimulated some thoughts. We haven't taken questions during the day because we had a lot of material to get through, but I know various speakers will be here. At the end of the session, there's drinks in the room where we had lunch and we had tea break. So please do stay, chat with the speakers. If you've got any questions, I'm sure others will be happy to answer them. And thank you all so much for coming and then supporting our employment extravaganza. Thank you very much.
Thank you.